How to create evidence for an EOT claim. The topic may look like manipulative. It is not to create an evidence something totally not available. So the intention of this presentation is that you may think that you don't have evidence, but you have the available data which are unassorted or scattered, which has to be aggregated to form an evidence. So why contemporary records are so important? Because the extension of time claims, either it is in the stage of claims or disputes, or it is in mediation or arbitration, evidence play a crucial role in all the stages. In evidence, contemporary records are the major role players. They are used to establish the timing of the delay, who is attributable, that is responsible, and what is the impact on the progress. Without them, the causation must be reconstructed. Reconstruct events using available data. So rebuild the data timeline. So using minutes of meetings, emails, the emails have the dates and the letters, then site visit reports, photographs. Photographs with timestamps will play a good role. And even verbal instructions, which were later confirmed in writings, can also be used. So you have to chronologically take these events and make a logical reconstruction based on the sequence of the events. The engage witness testimonies. So we have documents other than schedules, other than progress reports, which are less given importance. So you can gather those data. For example, site attendance register. When you want to show idle manpower charges, or we were maintaining the site manpower as per the commitment, you can use the site attendance register. Daily progress reports, when there are permit delays, when there are other delays with respect to daily activities, you can go with daily progress reports. Material delivery logs, if there are delays in material deliveries, or if you want to prove that the material was ready, but the site was not ready to start the work in terms of concurrency. So at that point, you can use material delivery logs. HSE incident records. They are used to give you productivity related evidence. For example, during the COVID, there was a reduction of 50% of manpower who were working at the site. And we were working for a particular project and we were not able to establish this because there was no any instruction from writing other than the general instruction from the uh, public sectors and the governments. So then there was an HSA record from the employer that it was an observation and non-compliance saying that 4 people are working at the trench, cable trench, where only 2 people has to be worked. So this was the evidence for the reduce in the productivity, and that's a disruption, and that has impacted the delay. So quality inspections and rework logs. So what are the any delays in the inspections and what are the more reworks? If you are an employer and there have been multiple reworks by the contractor, and you can use this as a record to prove the extension of time is not valid on the other side. So it goes both ways. So these prove work disruption or stoppages. RFI and technical records. So technical records are very important records like design um, drawings, philosophies, RFIs. They play a huge role. So the delay for the awaiting for the clarifications and what was the subject and what are the design gaps that were not properly conveyed at the time of contract award, late responses from the employers. So these are the strong indicators of employer cost delays. Informal records. So there is nothing called informal records in the EPC contracts. But we don't give much importance to this kind of records usually. emails and email follow-ups, WhatsApp and team messages, time-stamped site photos, vendor invoices and receipts, equipment title logs. These kind of contempt records are very seriously taken in arbitrations when the level of evidence increase. The first level of evidence will be the schedule, first level of evidence will be your accounted data or CA audited files. But when we go to next level, they will be asking for the invoices you have dispatched. They'll be asking for the salary receipts you have given to the employees. So these are mainly for the prolongation costs when it comes to invoices and receipts. So other emails, WhatsApps, they will be helpful to emphasize what are the delays that has been actually incurred. And even though they are not been recorded properly in letters or in notices, they are recorded in the secondary form of records, which are usually accepted as the form of records. Witness statements, fact witness statements, that people, those who have worked in the project, can give the statements what happened at the time of the delay between the employer and the contractor. So that they are used as factual, consistent, and linked to the project events. But when compared to the expert witness, these are even less um, priority, because factual evidences will be biased for the party which they are appearing for. For example, if their contractors, site engineer supervisors, they will be biased supporting the contractors, and it goes to the other way also. But when it comes to the expert witness, we'll see it later, and they perform unbiased, so their priority will be much higher than the factual witness. Contractual support. See, review the contract for the EOT classes, notices classes, whether they have been complied properly. What are the employer obligations like right of way, site access, permits? What are the approval timelines that has been agreed by both the parties before the starting of the contract? If the employer has failed to act on the time, then that can be used as a supportive entitlement. What are the employee's responsibilities usually in a generic way we have done? So the employer cost delays are usually due to late drawings, in case of in case of built construction, directly construction, and delayed approvals in case of design builds, design changes, which comes under variations, and it has also a time impact. Uh, Restricted site accesses, whether the site may not be ready or the other contractor may not be, is not ready enough to allow you to work with them. And so this has to be the link each to the actual project impact to create the uh, entire impact on the project completion. So expert opinions, here comes this expert witnesses, or the experts can reconstruct the schedule, establish causation, validate time impact. Expert analysis adds credibility to the weak records because they bring in expertise from the industry, and the industry perspective can reflect here. Industry standards. So while you are developing an EOT, you can go with the ACL delay and disruption protocol if your contract is not specifically asking for any delay methodologies. And you can rely on the FIDIC principles, and you can also rely on the AAC RP's recommended practices. It's not written here. And established legal precedents with respect to the certain jurisdictions, and how you can show the alignment with the best of the industry practice. That should be a strong narrative, because when in the level of discussion or negotiation between both the parties at the contractual level, not elevated to mediation or DAB or arbitration, this narrative may not be strongly required. But when it goes out of the parties, because the parties both are involved and they understand the language of the project. So when it goes outside for a dispute resolution process, the third parties who are coming to resolve the disputes may not be aware of the project right from the beginning. So for them, this narrative is very important, and like your client must very clearly explain what happened and why it happened, who caused it, and how it delayed the completion. So, and what are the evidences that backed up this legal logical story. Timely submission is very important. That not wait for the perfect records. Submit the EOT on time. Update with additional evidences. You have the right to update the evidences of the EOT At any stage, you get the EOT. So late claims fail more than weak claims. This is a very important statement you have to take in mind. You don't wait for the perfect timing to submit the EOT. You go with an imperfect claim, but add the evidences later instead of not claim. Thanks for watching. If you have any other topics you want me to discuss, please drop in comments. We'll keep discussing. Thank you.